Hi, I'm Brian Heidelberger, a partner with the law firm of Winston & Strawn in Chicago, and here today with another mini advertising law lesson. Today's law lesson, what advertisers and agencies should worry about in 2017. But first, I know we're back to work and it's bad. You might have faced this at home or felt like this yourself. Call.
I'm not going. I hate my life.
But I have good news for you. Well, no, actually I don't. There's nothing we can do about it. It sucks. 5-day week next week, people. What are we going to do about it? Well, first, let's talk about things to worry about in 2017. Influencer marketing. If you were in advertising, you must have said the word influencer about 1 million times last year, and it's going to continue for this year. So what do we need to worry about? Well, remember, last year the FTC went after Lord & Taylor for insufficient disclosure of connection between Lord & Taylor and their influencers. The FTC went after Warner Brothers for insufficient disclosure between them and their influencers. Just in December, the New York Attorney General went after several companies for, again, improper or no disclosure of connection. Obviously, we need a contract with our influencers. We need to monitor those influencers and take action to the extent that they don't disclose that they are being compensated or somehow affiliated with us. But what's really important is that in your contract with your disclosures or upfront, you need to decide what they are going to say. It's not enough just merely to tell the influencers you need to disclose pursuant to FTC rules. You need to come to an agreement ahead of time. It also can be something that's organic. I worked with client to create this video, but we do want to be careful. Something we learned from the Warner Brothers case, that statements such as "I got this for free" or "sponsored" are inappropriate where the client had input into what the influencer said. Now, we want to remember disclosures need to be at the top of the post, probably following the title. Viewers should not have to scroll down. Disclosure, as we know, in the bio of sponsorship isn't going to be good enough. And for videos, we want to make sure that there's disclosure, not just in the video, but my opinion is it should be in the description at the top as well. And if we're talking about streaming video, it needs to be in multiple points along the way of the video because people jump in and out. And of course, the disclosures need to be in easily read and size, color, and shading so people read and understand them. So what else do we need to worry about? Well, we're going to continue on this theme. It's disclosures and disclaimers. The FTC, courts, the NAD, they have told us that you can't use fine print to contradict statements in your advertising. So the FTC has told us you can't say lose 10 pounds in 1 week without dieting and then have a little tiny disclaimer that says diet and exercise required. But time and time again, we're seeing advertisers that like to shout things from the mountaintop and then assume that the legal disclaimer is going to take care of it. And we've seen from the FTC, it's not going to be acceptable. In 2013, the FTC gave us the .com disclosures telling us how to make effective disclosures. In 2014, they warned dozens and dozens of advertisers, major advertisers in Operation Full Disclosures about their fine print advertising, which wasn't sufficient. In 2015, the FTC gave us their native advertising enforcement disclosures, which again stressed the importance of proper disclosures. And then in 2016, we saw a number of actions against brands for failure to disclose material terms in a proper format, and that is going to continue in 2017. What else do we need to worry about in 2017? The DMCA safe harbor, what does that mean? The Digital Millennium Copyright Act provides safe harbor. That means that you aren't liable for copyright infringement damages for third-party content that gets posted to your website if you follow certain requirements. What do you need to do? Well, you need to have a DMCA policy and post it, and you need to abide by it. But you also need to have a designated agent with the Copyright Office. Now you're saying, Brian, we did all that like 5 years ago. Yeah, I know that. But what has happened is that a new regulation has been impacted, and before December 31st, 2017, you need to re-register. Lastly, transparency. Yes, that's a big word that we heard last year. It's going to be even bigger this year. What does that mean? The ANA commissioned a report that alleged non-transparent practices by media agencies. They said agencies were getting rebates which weren't returned to clients. The agency holding companies were buying media and then reselling it to clients without disclosing that the discounts they were getting from media was based upon the client's purchases, that the agency holding companies were pressuring media buyers to direct clients to spend on higher margin media. And agency holding companies had equity stakes in media suppliers but didn't disclose this to the clients. By the 4 A's, the Advertising Association came out and disputes that. They criticized the report. They said it was unsubstantiated, anonymous, one-sided allegations, and they issued their own guiding principles of conduct. So the ANA, what did they do? They recommended that agencies provide complete transparency in all transactions with parent companies, subs, affiliates, and related parties. They said the agencies need to disclose any conflict of interest prior to entering into any agreement on the advertiser's behalf, that they have deep audits of the media agency and its parent company, and that the agency CFO should be at the top level, should be accountable for all agency performance and compliance, and that advertisers should take ownership of the data. So what does that mean in 2017? What's going to be going on? Well, if you are an advertiser, you're probably going to be conducting audits of agencies, and you're going to be either negotiating or renegotiating or considering renegotiating your agency client agreements to incorporate some or all of those new principles. But if you are an agency, you're going to be struggling with all this. You're going to be struggling with trying to do your business and have these deep audits. You're going to be struggling with negotiating and renegotiating of contracts that are going to be very pro-advertiser, asking for heavy transparency. And you're going to be struggling with, are these requests really necessary? So we've got a lot of things going on in 2017. I hope that was helpful. And from myself and my family to yours, have a happy new year, and let's be careful out there.